Sandra set it up, and I've tried to go in there, I get that right away. And so then we both have to get online with the person, and she says, yes, it's all right if he talks to you. And, you know, Comcast, everything, all that way. Then the other question I had, and I think I know the answer, but this power of attorney goes on and expires at what moment?
Well, the power of attorney can go on for the rest of your life if you wanted to. I mean, I typically set it up so that it'll expire if you revoke it, and you can revoke it. It'll expire when you die, because a power of attorney only auzes somebody to act on your behalf and do what you can do. And that's a very, very common misunderstanding. You know, I'll get calls from clients who say, my husband passed away, but I know I don't need to worry about any of that because I still have his power of attorney. Well,
that's where it stops.
His power of attorney stopped having any power the moment he passed. So it only authorizes people to do what you could do. If we can't sign anything anymore because we're not alive, we can't do anything anymore and the power of attorney stops. That's when the will takes over. Okay, anything else?
I was just informed that you have to, if you want to talk to Medicare on behalf of your spouse, you have to notify them that he has permission or I have permission to talk to Medicare about each other.
That's did everybody hear that? The comment that she made was that she's just learned that Medicare requires that there's some advance notice or some way to tell them that it's okay to talk to you about your spouse's account. That's a new one on me, but doesn't surprise me one bit.
Well, this lady was telling me, and her husband had passed away, and she was charged a bill that they didn't procure. And she wanted to tell Medicare about it. They wouldn't talk to her.
It doesn't surprise me. It doesn't surprise me at all. I mean, the same thing is sort of true for tax returns. You typically need a power of attorney to sign a tax return even for a spouse. So it's getting crazy out there. And the only advice I can have for anybody is just make sure you keep your documents current and up to date.
Is a power of attorney an all or nothing thing, or can you have a power of attorney that gives someone authorization to transact business on your behalf for just certain areas?
So there are a couple of different kinds of powers of attorney. One is called a general power of attorney, which authorizes somebody to basically sign anything you could sign, do anything you could do. There are plenty of limited powers of attorney where you can limit it to a particular activity or a particular responsibility. Sometimes we do that for certain bank accounts because the banks are now doing their own, what I call check the box estate planning. You go in and open up an account and they're going to check some box that has significance about what happens to your account if you die and who's authorized to sign. So sometimes we'll do that for bank accounts. We use limited powers of attorney all the time when somebody is moving away but selling their house and they want to leave somebody with the authority to sign the closing documents. So the answer is yeah, we can do that for limited purposes. We want to be really specific when we do that. Other questions?
Does your next of kin have power over you, over your power of attorney people?
Next of kin has no authority at all unless you have no documents. The documents will always advise who's first in line to have whatever authority somebody's going to allow them to have. You only get, next of kin only has significance if you don't have anything.
A lot of times the next of kin has been out of your life for a long time.
Yeah. Yeah, my experience is most of the time next of kin is not a good choice. Okay, you want to shift gears a little bit? Any other questions related to some of this? Those are the documents that, and the decisions and the conversations you have to make sure people are going to do things the way you want them to do while you are alive, but maybe incapable of taking care of things yourself. Most important part of all of this. So let's start talking for a few minutes about what happens when we're gone. Now what documents do we use? A will, most common document people talk about. It's the most common document used, and still only 42% of Americans do this. So let's talk about what happens if you die and you don't have a will. Anybody have any ideas?
I think
Government takes over.
The state,
would determine that first.
well, the state will determine it, but the state won't get anything. It's called an intestate probate. That's Latin for without a will. Intestate. We have a will, we die intestate. If we don't have a will, we die intestate. So, and the government, the law, has a will written in there for us. And typically what happens if we don't have a will is that everything will go, well, it depends on the circumstances. I was going to say typically everything goes to a surviving spouse, but that's not necessarily true. It depends on whether it's community property or separate property. Even in a community property state, it can depend on whether there are kids from prior marriages and all kinds of things that can complicate this. So the bottom line is, it typically is not a good result when we have to have an intestate probate. So it's typically much better when you do the things that make you a responsible adult and make your own decisions about how this is all going to play out. Okay, a will is simply a set of instructions that appoints somebody. We used to call that somebody the executor or executrix. Now we have to be gender sensitive, so we call that person the personal representative. So it's a set of instructions that appoints the personal representative and tells the personal representative what to do with your stuff. See, there's that term of art. Again, it's a function of picking the right person. And I always encourage my clients to think about succession. I appoint this person, but if they're not readily available or willing, because there's nothing that says they have to, then we appoint this person and move down the line as many as it makes sense to do. The instructions that they're asked to follow can be really simple, can be really, really, really complicated. In order for a will to have any legal effect, there are two things that have to happen. Any ideas? One is pretty obvious. You've got to die. Your will has no legal effect until you die. You are allowed to change your will. You're allowed to change those instructions. You're allowed to change it all, including just tearing it up, right, as long as you are alive and competent. So your will has no legal effect until you die, and it must be admitted to the probate court. Now, I know, almost any hour of almost any day, you can turn on some television channel and you will find Susie Orman. And Susie Orman preaches that everybody has to avoid probate. Probate is this terrible, horrible, no good, very bad thing. And everybody needs to do things to avoid probate. And that was true in Washington some years ago now. Not so true in Washington anymore. Still very true in many other states. Certainly every state east of the Mississippi, some of the western states are changing for whatever reason. And I can't explain it, but for whatever reason, Washington is ahead of the curve on this. We changed the probate laws in Washington so that it's efficient, it is less costly, it moves along pretty quickly, it's fairly simple to administer, should be fairly simple to administer. So in Washington, if all of our assets are in Washington, avoiding probate isn't a big deal anymore. Used to be we did things that would help avoid probate. Sometimes we still do things to avoid probate, but avoiding probate in Washington is not something we need to worry about anymore. I will argue, after doing this for as long as I've done this, that in some cases, having a probate is a good thing because it really cleans it all up and it's orderly and it's nice and it's done. So don't be afraid of probate in Washington. Now, if you're one of those lucky people that has that winter place you go to in Arizona or Palm Desert or the timeshare you have in Hawaii or that farm property you inherited in Iowa years ago, now you have assets in more than one jurisdiction. Now you own things in Washington and the other states. And when you own things in other states, you have to probate them in each state where you own something.
Is that true if you have that property held in Washington LLC?
See, now you're making it a little more complicated and a little clever. And the answer to that is no, it doesn't have to go through probate if you hold it in an LLC. But there may be tax problems in doing it that way.
Well, Arizona has a state tax, so.
Arizona has a
You could
state-
avoid the state tax if you held it in Washington LLC.
Arizona has a state income tax. They do not have a state estate tax. Arizona is one of the better places to die. And it's a good place to go and die after you've finished earning income, so you don't have to pay them income tax. Now, doing that timing isn't always so easy.
Yeah.
But Arizona does not have a state estate tax. Okay? Interestingly enough, neither does California.
Do you have to have a power of attorney and healthcare power of attorney and all, and healthcare directive? Because we do go to Arizona for 6 months out of the year in that state.
So Arizona is used to you coming down there. There are lots of people from up here that go down there. As long, again, I can't guarantee you they're going to honor it, depending on which hospital you go to or which doctor you see. But I will tell you that the odds of them honoring it are much greater if everything's current within the last few years. And it's been done in a way that they have confidence that you were advised about them, not just filling out a form you got on the internet. That's what troubles them these days. Okay? So yes, feel comfortable that what you have in Washington will work down there if you need to. But get it current.
The other thing, when my late husband passed away, we had a community property form that was signed and notarized, so I didn't have to go through probate.
Okay, do you hear what she said? She mentioned another tool called a community property agreement. How many of you know that Washington is a community property state? For the men in the audience, that means that what's yours is hers, what's hers is hers.
All goes to
So I don't believe you said that. Community property is a concept that is unique to 7 states. Washington is one of them. It is an old Western-style concept for how married couples own assets. It presumes, Washington law just presumes, that what a husband and wife own, they own together as marital community property. As opposed to the way it's done in most states where I own what I own, my wife owns what she owns, and that's the way it works. In Washington, this presumption about community property is just a presumption. So when we die, if it's all community property, we have to prove the presumption. So the way we prove that presumption is to open a probate. Unless, while we're both alive, Diane and I sign a community property agreement which confirms that presumption and says, when one of us dies, everything we have automatically belongs to the survivor. Great tool. Terrific tool. Makes it so easy. It doesn't get any easier when one spouse dies if you've got a community property agreement. But it isn't always the best tool. It isn't always the most efficient tool to use depending on the tax circumstances. And I'm going to get into the tax issues in a minute, so hopefully you will begin to get a grasp about why I get concerned about that. It's also not the best tool if you have, if it's a second marriage and there are children from prior marriages and we're trying to deal with the various expectations, because, you know, that's what we have when we're waiting for somebody to die, the expectation we're going to inherit something. When you're trying to deal with those expectations, and you've got all these unrelated parties out there, a community property agreement can be difficult. But for most people, for most of us, community property agreement should be in the toolbox. Should be one of the things these days that works. Now, since we're there, let's talk about the taxes. Any other questions about community property agreements before we move on that?
Was a living trust a step up from that when it goes beyond?
Okay, a living trust.
Is it similar to?
Living trust is a really great tool, a really great way to do this kind of planning. It was the preferred option years ago when probate in Washington was more difficult than it is today. A living trust is a way of owning your stuff so that it doesn't have to go through probate. Probate is about inviting that personal representative to transfer my stuff to whoever I want it to go to. So probate is the process of transferring. If I set up a living trust now, and I transfer all of my stuff in there now, and all I own is the exclusive right to be the trustee of that trust, when I die, if I don't own anything, if my trust owns it, there is no probate. So that's how we've used it to avoid the probate. Since probate in Washington has gotten better, the need for that as a tool has gone away. Still a great tool to use, and it's probably the best way to organize things and structure things so that this will be simple on the next generation, when they have to handle it. It's also a really wonderful tool if you own things in multiple states, because now we put all of that in the living trust, and we don't have to have probates in each jurisdiction. Got it? Excuse me. Okay. Taxes. Anybody have an idea of how much you can pass tax-free these days? How big can your estate be before you pay any taxes to the state or federal government?
2 million.
7 million.
Okay, I heard lots of numbers. So thanks to the most recent federal tax law, the amount that a married couple can pass free of any federal estate taxes is now approaching $23 million. If you have an estate that large and you're sitting in here, we need to talk. $23 million. So that's a change that was made in this most recent tax law. It will change back to what it was, which was $5 million adjusted for inflation every year. It'll change back to that in 2025 unless they do something in between. I can't stand here and tell you with any integrity at all that I have a clue what the tax laws at the federal level are going to look like next year or the year after or 5 years from now. I don't know. And it may all change depending on what happens in this upcoming election in November.
Why is there a clawback? Why did they put it out at 23?
It's a sunset date that the tax laws that they put in place will go on to 2025 when that administration can't be in office anymore. And that's very common that they sunset those things out there like that. So it'll come back. So we now have 23, it'll continue to gradually increase until 2025. If they don't do anything, it'll drop back to probably close to 6 per person. Still a lot of money. So for most of us, we don't have any federal estate tax concerns to be worried about anymore, at least for now. The federal law also has a couple of other benefits associated with it. For married couples, we used to have to make sure we captured both persons' exemption amount so that we could use both of them. We now have a concept in the law called portability, which allows that in states where my wife might have $2 million, but I might have $2, and the consequence if she dies, or if I die, there may be lots of exemption I'm not using that she won't get to take advantage of. Now, the federal law says that whatever we have together, we can combine it, and it happens automatically. So that's a nice deal. The federal law also has another big advantage for some people. Everything you have, every investment you have has what's called a basis. You know what that term means? Basis is the tax term for largely what you paid for something. So your house, what you paid for it, what you added to put on that new roof or done some improvements, that's what your basis is. When you sell it, presumably for a higher fair market value, it's the difference between the basis and the fair market value that is the capital gain. We get taxed on capital gain. Under current law, when we die, the basis on almost everything we own steps up to whatever the fair market value was on the date we passed away, and all of that capital gain starts over. So it can be a huge advantage for families where husband and wife own things that they invested in a long time ago. That Microsoft stock used to be a good example, not a good example anymore because it's not much dividend. Not much dividend from Starbucks either. But in any event, you get this stepped up basis which allows the surviving spouse to sell things without the capital gain tax and reinvest it in something that's going to produce more income. Because remember, when one spouse dies, the Social Security numbers change a little. Okay, that's called the stepped up basis. Now, Washington has its own estate tax, and it's tricky. Washington's estate tax is something that we got in 2005. Governor Gregoire put it in place. Those of us who practice in this area knew that what it was unconstitutional. We knew it. But the way the system works, you can't challenge it until you get the right case that's designed to challenge the constitutionality of it. So after a couple of years, that right case came along, that it got challenged. The state Supreme Court said, yep, that tax is unconstitutional. It was put in place improperly. So not only do you need to take it out, but you need to refund everything you collected on it. And of course, they were allowed to deduct all of the administrative costs that had been associated with the Department of Revenue doing their work about it. But in any event, they refunded most of what was there. Within just a couple of months, Governor Gregoire tweaked it. She turned a little bit of the language about that law, enough to make it pass constitutionality. And then they did a really smart thing. They put it on the ballot. And maybe you remember this, but back about 2007, 2008, it was a ballot measure that Washington had an estate tax, and it was sold on the basis that you really ought to vote for this because only the very wealthy are going to pay for it. Because we're going to give you all $1 million. So the only people who have more than $1 million are going to pay this tax. And it passed. Not overwhelmingly, but enough, and it passed. So it is now law in the state of Washington. Everybody here will be subject to some form of estate tax. We also have an exemption, an amount we can exempt from that tax. That amount is currently $2.2 million each. It is also subject to a formula that lets it move around, generally up, based on cost of living increases and some of the standard formulas that they use for those things. So today it's $2.2 million. But remember, to get to that number that is the value of our estate, you have to add in the fair market value of everything. We don't care about what's the tax assessed value of your home. We want to know what's the market value. We don't care that you have a little bit of cash value in your life insurance. We want to know what's the death benefit of that life insurance. We don't care that maybe you owe some money on the house. We want to know what its fair market value is. So people get to that $2 million number a lot faster than you might think. It's a lot easier these days when you start adding up all the pieces. I had a guy in the office today who joined a whiskey club 20 years ago, and he started buying these interesting bottles of scotch, some of which are now worth 6 figures. 6-figure bottle of scotch. So I was really trying to get him to bring one in and taste it. I was even willing to trade a little bit of my fee. He said no. So the point is, it's pretty easy to add up those numbers and get to where that $2.2 million threshold is these days. Federal law, I told you, allows husbands and wives to use this portability concept and use the combination of their 2 exemptions. So everybody has an $11+ million exemption. For married couples, it automatically means 22 going on 23. In Washington, that's not the case. In Washington, the husband has 2.2, the wife has 2.2. It is not automatically put in place. So the will or the living trust needs to absolutely be structured so that we use a tool called a credit shelter trust. Credit shelter trust is designed to shelter or protect the credit or the exemption amount that's available to whoever dies first. So if I've got a couple who has $3 million of value in their estate, and they don't do this, and one of them dies, and they use a community property agreement, everything goes to the surviving spouse, which is typically what they want anyway. The survivor now has $3 million in his or her estate. When that survivor dies with $3 million, and we can only protect 2.2 of it, we have $800,000 that's going to be taxed at 20%. If instead, both wills had a provision that said, when I die, I leave everything to my surviving spouse, but I'm also going to give my spouse the opportunity to do some tax planning if it's appropriate at the time. And if it's appropriate, you can take some of my half and set it aside in a credit shelter trust to take advantage of my exemption. So now if they had that $3 million, first one to die can control $1.5 million. If we put $1.5 million in the credit shelter trust, the survivor has $1.5 million. We can protect 2.2 of it. We just hit a home run. That should be in everybody's wills because we don't know what they're going to do with these tax laws. There is a lot of conversation at the state legislative level about dropping that $2.2 million exemption that each of us has back to $1 million. That's where we started. They could do that as early as next spring in the next legislative session. But they're talking about things like that. As they need money, that's one of the easy ways for them to get it because then people don't complain about the taxes. So it's something you need to keep an eye on. It's something you need to get some good advice about for your own wills. It can be set up so that it is absolutely flexible to adapt to the circumstances at the time.